Good day, everyone. Welcome to our fourth topic on the regulatory framework, Republic Act number 1405, as amended, otherwise known as the Secrecy of Bank Deposits Law. Right. Welcome to the continuation of our series of lectures on the regulatory framework. So let's begin our discussion with secrecy of bank deposits, the purpose why the law was enacted by Congress. This particular law, the bank secrecy law, as we all might have heard about it, or I might have raised this one under our topic in Anti-Money Laundering Act, was enacted by Congress to encourage deposits in the banking institutions in the Philippines, as well as to discourage private hoarding so that banks may lend such funds and assist in the economic development of the country. To my mind, the bank secrecy law was actually enacted because of the culture of distrust in the Philippines. That because we don't want other people to pry into our privacy and to have an idea of how much we are worth or how much money we have accumulated, people tend not to deposit in banks. And it's important for the survival and the growth of the banking industry in the Philippines for the population, the citizens of the country, to be able to trust the banking system, give up their money, deposit it with the banks so that banks can be able to raise enough funds that they may be able to lend to businesses in the country. Because we are trying to spur economic development, and you can only reach this one if banks may be able to lend money to businesses as they are facing growth or planning to expand their businesses. So with this, to encourage the population, Congress thought that maybe we will have a law that will protect the bank deposits from being spilled, from being shared, and from being disclosed by the banking institutions. Hence, this was enacted. Also, because people now are encouraged to deposit in banks, the culture now, or the habit of Filipinos to hoard cash in their own homes has now decreased because people have appreciated that, yeah, we can actually put our money in these banks. We can deposit here because we can earn, albeit minimal interest, but at least it's safe with the banks and we will not be discovered, or I should say, this will not be disclosed to our friends or to other individuals. So let us put it there. So no one's hoarding now cash. And because cash is now readily available for lending and financing purposes, it actually assists now the government in its effort to deliver economic development, especially in the countryside, which is supported by the existence of our rural banks. Okay, so these are the two purposes why we have the bank secrecy law. Now, what are the coverage of bank secrecy law? Okay, so obviously, since it refers to the secrecy of bank deposits, there are certain prohibited acts under Republic Act 1405. The first prohibited act will be the examination, inquiry, or looking into all deposits of whatever nature with banks or banking institutions in the Philippines. Included in this prohibition to look into or to inquire in the deposits would be investment in bonds issued by the government. And this particular prohibition covers any other person. Okay, so by any person. Now, it also covers government officials or any other offices. So note, there is a blanket of prohibition now as to the examination, inquiry, or looking into all deposits of whatever nature with banks and banking institutions. But remember, when I raised a certain exemption to this supposed to be absolute rule, is the covered or suspicious transactions under the Anti-Money Laundering Act. So the Anti-Money Laundering Act class was passed by Congress later on. This was a previous law. So previously, this is an absolute rule. There is a provision as to examine, to inquire, to look into the deposits of banks and banking institutions. However, with AMLA, this is already limited considering that in AMLA, we have defined now what are considered to be covered or suspicious transactions that are reportable by bank or non-bank financial institutions to the Anti-Money Laundering Council. So take note of that. The second prohibition will be the disclosure by any official or employee of any banking institution to any unauthorized person of any information concerning said deposit. Managers, executives, or any individual working for the bank cannot disclose information with respect to your bank deposits. And that's why there is a narrow corridor now for investigators in the Philippines, such as the tax officers. So we call them the BIR examiners or the revenue officers, to examine your bank deposits because of this prohibition. Unless, of course, we fall under those narrow exemptions, this particular provision under Section 3 of Republic Act 1405 actually prevails. Okay? So what are the acts not covered by this prohibition? If you are a non-bank official or employee, you are not covered by the prohibition. Neither is disclosure by a bank official or employee of information about bank deposit in favor of a co-employee in the course of the performance of his duties covered by the prohibition. Obviously, one who's working with a bank can disclose banking information with a co-employee, provided that the disclosure was actually made in the regular or ordinary course of the performance of their respective duties. So, for example, both of you are working with the Bank of the Philippine Islands or BPI. Obviously, there will be inquiries between each other as to certain accounts because the two of you might have handled it. Are you prohibited from disclosing such information? Obviously not, because it would hamper your work and your responsibilities as banking employees. You can share with one another. However, malicious disclosure with a co-employee, especially the co-employee has no right or no access whatsoever for that kind of information and you voluntarily disclose it, then you actually violated the prohibition. But if such disclosure is within the bounds of the ordinary course of the performance of your duties as employee of the bank, that is not covered by the prohibition. You only have to think logically, obviously. These employees cannot work properly if they're prohibited. Absolutely, right? So this has you have to bear this in mind, that this particular disclosure is not what is contemplated under Section 2 and Section 3 of Republic Act 1405. Right. Now let's proceed to the application of the law. Okay. We have a sample question here. Manosa, a newspaper columnist, while making a deposit in a bank, overheard a pretty bank teller informing a co-employee that Gigi, a well-known public official, has just a few hundred pesos in her bank account and that her check will on probability bounce. Manosa wrote this information in his newspaper column. Thus, Gigi filed a complaint with the City Fiscal of Manila for unlawfully disclosing information about her bank account. First question, will this said suit prosper? Explain your answer. Now, accordingly, this particular case will not prosper. The suit will not prosper because it is clearly provided under Section 3 of Republic Act 1405 that it shall be unlawful for any official or employee of a banking institution to disclose to any person other than those mentioned in Section 2 of the said law any information concerning said deposits. Manosa, as a columnist, is not one of those persons contemplated under the law. Furthermore, he merely overheard what appeared to be a vague remark of the bank teller. Therefore, it is not in a sense of an inquiry or a disclosure. So this is not what is contemplated under the Republic Act 1405, that the particular information must be disclosed. It is a vague conversation by two employees, and therefore there was no active act of disclosing such information. The worst that could be filed by Gigi here would probably be under libel, considering that it must be maliciously painted as someone who cannot afford to pay her obligations, or somewhat making her like a sort of a criminal for violating BP 22 or the anti-bouncing checks law, or probably Article or Section 315 of the Revised Penal Code under swindling or estafa. So this is not a violation of Republic Act 1405. Continue. Now, second, supposing that Gigi is charged with unlawfully acquiring wealth under Republic Act 1379 and that the fiscal issued a subpoena ducis tecum. Subpoena ducis tecum, this is a subpoena asking now an agency, authority, or a person to produce papers, implements, articles, or documents with respect to an investigation or ongoing investigation or a trial. So, this is separate to a subpoena ad testificandum, which is a subpoena to call you to court to testify. Ducis tecum is more of producing documents or evidence with respect to an investigation or a trial. Now, question, may Gigi validly oppose the issuance of the subpoena ducis tecum on the ground that the same violated the law on secrecy of bank deposits? The answer is no. Gigi cannot oppose the issuance because the law provides as an exemption from the coverage of Republic Act 1405 that upon order of a competent court in cases of anti-graft and corrupt cases, the examination of the deposits may be allowed. So you refer that one to the particular section of Republic Act 1405 as an exemption to this rule. The rule is that you cannot, these particular bank deposits shall not be subject to inquiry or investigation, except of course if this is upon issuance of a bank inquiry order issued by a competent court with respect to anti-graft and corrupt cases. Note that we've discussed under AMLA the issuance of a bank inquiry order. Note that in the Philippines, it is only upon the issuance of a bank inquiry order that our bank deposits may be open. And note, if you could remember properly, that the bank inquiry order can only be issued by the Court of Appeals or by a competent court with respect to this particular investigation upon determination of that court of probable cause. Probable cause meaning a cause which a prudent man is can be moved or can be convinced that there is an existence of a particular violation. And with respect to this particular question, a probable cause as to the commission of graft and corrupt practices. Right? Now, let's proceed to the deposits discovered. Okay. Now, all deposits of whatever nature with banks or banking institutions found in the Philippines, these are investments in bonds issued by the Philippine government, its branches and institutions, and it also covers trust accounts. So these are what fall under the definition of deposits discovered. So what is the meaning of the phrase deposits of whatever nature and kind? If you will say whatever nature of kind, Republic Act 1405 is no longer limited to deposits governed by law on loans giving rise to the creditor-debtor relationship, but it covers also funds of whatever nature so long as the bank may use and utilize it in authorized loans. So meaning it is no longer limited to the deposits that we have defined under our previous discussions, especially the deposit we've defined under the general banking law. So here, all deposits of whatever nature or kind contemplates even those funds received by the bank that do not fall under the creditor-debtor relationship, meaning the usual deposits that we contemplate. Deposits in the context of our secrecy of Philippine currency deposits would include deposits of whatever nature and kind. This include now those funds deposited in the bank that are under the usual creditor-debtor relationship, as well as funds invested in the bank like trust accounts. This was enunciated by the Supreme Court in the case of Ejercito versus Sandigan Bayan on November 30, 2006. Alright? This was raised during the investigation, the continuing investigation by the Sandigan Bayan against former President Joseph Ejercito Estrada as a continuation from his impeachment proceedings in 2001. Here, the question, the issue in question was whether the particular secrecy should only limit to the usual bank deposits, and if these deposits shall be discovered, this should contemplate only those considered to be the regular deposits, which give rise to a creditor-debtor relationship between the depositor and the bank. But the Supreme Court said here, no, it may also include any funds invested or has received by the bank from a depositor, even if this is not a deposit, like those under trust accounts. Remember, in this particular investigation, the amount of money deposited in equitable PCI are under the name of Jose Pidal that are in trust for, or the beneficiary is the former president. The money deposited under the trust agreement is intended not merely to remain with the bank, but to invested by elsewhere. To hold that this type of account is not protected by the Republic Act 1405 would encourage private hoarding of funds that would otherwise be invested by banks in other ventures, contrary to the policy behind the law. Right? Because remember, logically, the policy of the law is to discourage hoarding. But if we would limit now the coverage of the secrecy of bank deposits to a certain segment of funds that the bank is receiving, and therefore it defeats the very purpose of the law, because there are a huge chunk of funds being received by the bank that may not covered, and therefore depositors may decide not to deposit them because they're not covered by the secrecy. Alright? However, despite such pronouncements that trust funds are considered deposits, trust funds remain not covered by the Philippine Depository and Insurance Corporation, or the PDIC. Alright? So take note that the inclusion of trust funds in the definition of deposits is limited only under Republic Act 1405 or the secrecy of bank deposits. Outside of this particular law, trust funds are still not considered deposits, and therefore they are not insured under the PDIC. Right? Now let's to the continuation. The confidentiality granted by Republic Act 1405 does not extend to letters of credit and trust receipts. Right? It does not also extend to bank drafts and promissory notes. Take note, however, that this particular provision, or this particular non-inclusion of letters of credit and trust receipts is still not a Supreme Court ruling, but rather an opinion issued by the Secretary of Justice, number 5, series of 1982, as well as opinion of the Secretary of Justice number 126, series of 1989. So these are mere opinion issuances by the Secretary of Justice and not yet a Supreme Court ruling. But this could serve as a guidance of how the Department of Justice and the Secretary of Justice and his team contemplated that these particular documents or implements, like the letters of credit and trust receipts, do not qualify as deposits and granted such confidentiality or secrecy protection under Republic Act 1405. Now let's proceed to the exemptions. There are instances where examination or disclosure of information about deposits can be allowed. These are exemptions to the prohibition. First, if upon written consent of the depositor. Obviously, this will serve sort of a waiver. So if the depositor writes the bank, telling the bank that I am allowing this particular review of my bank accounts or this examination of my bank accounts, it may do so, because this will be tantamount to a waiver. This examination may also ensue in cases of an impeachment. So who are the impeachable officers or impeachable government officials? Obviously, we have the Vice President, the President of the Republic of the Philippines, and members of the Supreme Court. These are impeachable officers. Upon order of competent court in cases of bribery or dereliction of duty of public officials, in cases where the money depositor invested is subject matter of a litigation. Note, class, that these are provided under Section 2 of Republic Act 1405. Other instances include upon order of the Commissioner of Internal Revenue, the BIR, in respect of the bank deposits of a decedent for the purpose of determining such decedent's gross estate. Pag may manamatay, and of course, the BIR will have to determine the estate tax to be imposed against the estate of this decedent, the one who died. Obviously, the Commissioner of Internal Revenue is authorized to issue an inquiry order as to the bank deposits of the decedent. But take note, the limitation is the bank deposits of the decedent. Also, upon order of the Commissioner of Internal Revenue with respect to bank deposits of a taxpayer who has filed an application for compromise of his tax liability by reason of financial incapacity to pay his tax liability. Pag nag-compromise ka with the BIR because you are incapable of paying your tax liability, that gives now the Commission of Internal Revenue the authority to examine and to inquire with your bank accounts to verify if you're indeed not liquid enough to settle your pending tax liabilities. Also, the Commission of Internal Revenue is authorized to inquire into your bank deposits of a specific taxpayer upon request for tax information from a foreign tax authority pursuant to an international convention or agreement on tax matters to which the Philippines is a party. Example, if you have income in the United States and you have failed to file your income tax returns or to settle your income taxes or your tax due to the IRS or the Internal Revenue Service, and they subjected you to an investigation and you're already in the Philippines, and since you are a citizen of the Philippines, you are also covered by the Philippine jurisdiction, and the IRS would inquire as to your own bank deposits with respect to their tax investigation, the Commissioner of Internal Revenue may inquire into your bank deposits following now the international covenants or agreements or treaties to which the Philippines is signatory. So this is bound by certain tax treaties or tax agreements by the Philippines with, say, the United States or other countries to which we have a pending tax treaty or effective tax treaties. Also, in case of the dormant accounts or deposits for at least 10 years under Unclaimed Balances Act, meaning you have a bank account in a particular bank and then it was inactive. May balance siya, but you did not withdraw it. And after 10 years, no movement whatsoever of a particular bank account, that's why it was considered dormant, then that could now be inquired. Because there is a provision now under Unclaimed Balances Act as to the manner of disposing these unclaimed balances deposited with our domestic banks. The prohibition against examination of bank deposit does not preclude its garnishment to satisfy a judgment against the depositor. Note that we cannot, or agencies cannot examine your bank deposits. But say, for example, there's already a final judgment executory against you by the BIR, and you fail to appeal it, or you've already run out of remedy, and there's already the final tax assessment or final assessment notice or FAN or FAN, and then you did not settle these tax liabilities, and then the BIR was aware of your bank accounts, existing bank accounts. However, they're not aware of the bank balances. The BIR can issue an order of garnishment to these banks for banks to later on freeze the balances in order for them to be used to settle your tax liabilities. Also, the Presidential Commission on Good Government or PCGG may require the production of bank records and other materials to its investigation. This is an opinion of the Secretary of Justice issued in 1987. And of course, the Anti-Money Laundering Council may inquire into any deposits with any bank in case of violations of Republic Act 9160 or the Anti-Money Laundering Act if there is probable cause that it is related to an unlawful activity. Remember our discussion in our previous videos where the AMLAC must first determine probable cause. And then the AMLAC will file now a petition before the Court of Appeals for a bank inquiry order to which the Court of Appeals will have to determine independently its own probable cause in order for the issuance of the bank inquiry order with respect to the petition filed by the AMLA, either because there are violations of Republic Act 9160 or that there are probable cause that these particular banking transactions are related to the list of unlawful activities. Right? Now, another exemption will be the PDIC and the Bangko Sentral ng Pilipinas may examine deposit accounts and all information related to them in case of the finding of unsafe or unsound banking practices. Now, we have mentioned several times that of course an exemption to the bank secrecy law is if there is a court order. There is a court order in cases of unexplained wealth under Section 8 of Anti-Graft and Corrupt Practices Act. This was ruled by the Supreme Court in the case of PNB versus Gancayco, ruled September 30, 1965. A court order in cases filed by the Ombudsman and upon the latter's authority to examine and have access to bank accounts and records. So when there is a pending case with the Ombudsman now, within the bounds of its authority, have the right or the power to examine and have access to bank accounts and records. This was ruled under Marquez versus Desierto, September 11, 2003. Remember, Desierto was the former ombudsman. He was the ombudsman during the time of President Joseph Ernesto Estrada. I think the Marquez here is Joey Marquez, former mayor of the city of Parañaque. Another without court order, however, is if the AMLAC, the Anti-Money Laundering Council, determines that a particular deposit or investment with any banking institution is related to HK Mads. Remember the exemptions that we have discussed under AMLA, that no need for an inquiry order, no need to file before the Court of Appeals of a petition for an inquiry order if the particular deposit or investment with probable cause believed by AMLAC to be related to hijacking, kidnapping, murder, destructive arson, and violation of the Dangerous Drugs Act, as well as commission of the acts of terrorism or in violation of the Human Security Act. Now, also, another exemption under the bank secrecy law will be in case of the law is repealed, superseded, or modified by any law to the contrary. Alright. Now, let's proceed to the foreign currency deposits. Now, foreign currency deposits are covered by Republic Act 6426, otherwise known as the Foreign Currency Deposits Act. Now, is there secrecy of foreign currency deposit in the Philippines? The general rule is that foreign currency deposits cannot be inquired or looked into. All foreign currency deposits are absolutely confidential. Note, sinasabi sa Section 8 of RA 6426 that all foreign currency deposits are absolutely confidential. This is a special law designed specially for foreign currency deposits in the Philippines. While this particular subject topic is Republic Act 1405, which covers all bank deposits in the Philippines, it is the general law which does not nullify now the special law on foreign currency deposits. Take note that it is a well-entrenched principle in the Philippines that a special law prevails over the general law. And since the bank secrecy law or the Secrecy of Bank Deposits Law, Republic Act 1405, is the general law, therefore, RA 6426, a special law, must prevail. And therefore, the secrecy of foreign bank deposits will prevail, albeit the fact that there were exemptions provided under 1405. Now, the surety which issued a bond to secure the obligation of the principal debtor cannot inquire into the foreign currency deposits of the debtor, even if its purpose is to determine whether or not the loan proceeds were used for the purpose specified in the surety agreement. The foreign currency deposits cannot be examined without the written consent of the depositor. The subpoena issued by the bank should be quashed because foreign currency deposits are not subject to court order except for violation anti-money laundering law. Okay? Therefore, except for anti-money laundering law violation, AMLA violations, it seems that the foreign currency deposits secrecy would be absolutely confidential. In fact, they cannot be subjected to subpoena, ducis tecum, or any form of subpoena. Unless, of course, this is related to violations of the AMLA, which is the commission of unlawful activity to which these bank deposits may be related, or, of course, these are covered transactions. Right? Now, what are the exemptions to the secrecy of foreign currency deposits? Hindi din pa talaga absolutely confidential kasi may exemptions pa rin. Well, obviously, laws kasi class evolve. It may appear to be absolute, but as we apply the law, there are certain scenarios or conditions that our Congress may not have envisaged. This is especially true when, in fact, that when our Congress isn't really now comprised of the brightest of the brightest of the bunch. Like, they're not really the sharpest tool now. So what are the exemptions to secrecy of foreign currency deposits? First is the depositor has given his written permission. That is very common. Because again, it's your consent. That's your bank account. If you're giving it permission, then who the law would actually stop you from? Like, say, you can do it, right? When the funds deposited in a joint foreign currency savings account belonged exclusively to one of the depositors and held in trust for him by other depositor, and the other depositors unilaterally closed the joint account and transferred the funds to a personal account, the latter cannot invoke the exemption from court processes under Republic Act 6426 because she is not the owner of the deposit in the account. Consequently, the depositor who owned the funds can have her enjoined from making withdrawals from her personal account. This was ruled in Van Twest versus Court of Appeals, February 10, 1994. Another exemption was in a father who sued his daughter for illegally withdrawing funds from his foreign currency deposit and transferring to another bank in the name of her sister can inquire into the deposit of the sister because the money deposited actually belongs to him. This was ruled in China Bank Corporation versus Court of Appeals, December 18, 2006. And the exemption from court process of foreign currency deposits under RA 6426 cannot be invoked by a foreign transient who raped a minor, escaped, and was held liable for damages to the victim. The garnishment of this foreign currency deposit should be allowed to prevent an injustice and for equitable grounds. The law was enacted to encourage the foreign currency deposits to accumulate in the Philippines and not to benefit a wrongdoer. In this case, class, what the application of the law in the case of Salvacion versus Central Bank of the Philippines, August 21, 1997, was to go against the secrecy of foreign currency deposits because what the court upheld in this ruling is the paramount welfare of the child abused by the foreigner. So here, the foreigner's foreign currency deposits are removed from the ambit of the bank secrecy laws, meaning from the confidentiality that the law bestows upon it, because this foreign currency deposits will be used now to indemnify damages caused by this foreigner to the innocent child abused by him. So what the court here has done, class, is actually to weigh the laws, different laws, and apply which is more beneficial or more justiciable in this case. And here, more justice is served if the particular foreign currency deposits will be made an exemption in order for these cash or proceeds be given as an indemnity or for the benefit of the victim. Because again, if we uphold the foreign currency deposit secrecy, it's more of like the law is used to benefit the criminal or the wrongdoer, right? So this is more of in keeping with the principle that we are not a country merely ruled by law, but we are a country ruled by equity. When it seems that the application of the red letter of the law will not result to the delivery of justice, here we apply the concept or the principle of equity. All right? Now let's proceed to the other exemptions. When the Commissioner of Internal Revenue is authorized to inquire into the bank deposits of a decedent for the estate. Kasi kung ang decedent may dollar account, class, it must be covered by the inquiry order of the Commission of Internal Revenue to determine properly the total value of the gross estate for the purpose of computation of our estate tax. Any taxpayer who has filed a compromise application and any specific taxpayer upon request of a foreign body or authority with respect to international convention or agreement. Similar to Philippine deposits. This time, this particular exemption covers even the foreign currency deposits. Another exemption will be when AMLAC may inquire into the bank deposit with a bank or financial institution in case of violations of Republic Act 9160. If there is probable cause that that particular banking transaction or bank account is related to an unlawful activity. This is when an ex parte application by a law enforcer authorized by the Anti-Terrorism Council, the justices of the Court of Appeals designated as a special court to handle anti-terrorism cases may authorize the examination of deposits in a financial institution upon finding a probable cause of the commission of terrorism or conspiracy to commit terrorism. The PDIC as well and the BSP may examine deposit accounts and all information related to them in case of finding unsafe or unsound banking practices. And of course, AMLAC can investigate any property of funds related to financing terrorism, property or funds of any person if there is probable cause to believe that he is committing or attempting or conspiring to commit terrorism or financing terrorism. Right? So this is the end of our fourth topic under the Secrecy of Bank Deposits Law.